May I proceed, Your Honor?
No, please, hold on.
Thank you.
All right, counsel, we're ready to proceed.
Good morning. May it please the Court. My name is Keith Minoff. I represent the plaintiff in this case, Peter G. Cook. Your Honors, this is a very important case, not just for Mr. Cook, but for all men and women working for companies that have chosen to organize themselves as limited liability companies, or LLC. This is a case of first impression. It presents a pure question of law for the Court, which I'll discuss in a minute. But the case is very important because the Court's decision in this case will determine whether employees of LLCs like Mr. Cook will be permitted to pursue claims for late wages or unpaid wages directly against the individuals who engage in the illegal wage payments as the legislature intended, and as is true for all other employees.
Well, I mean, you can proceed against the LLC. It's a company.
You can, and Mr.
He did, didn't he?
And he has, but like many employees who don't get paid, often the reason they're not getting paid is because the business is going down the tubes, and that's exactly what has happened. In this case, the LLC, actually, at this point, it sold its assets, it's not in business, and Mr. Cook's only meaningful remedy is against these individuals.
So is it in those circumstances where the managers of an LLC company might be personally liable, or is this just something whenever you file suit against an LLC for a wage claim, you just include all the managers?
Yes. The statute provides the opening phrase of Section 148. It doesn't speak in terms of employers. It says every person with employees in his service.
Okay, so I am a person. My secretary works for me. Am I her employer?
I think. Well, I think.
Well, she does my work. Am I her employer?
Yes. Are you organized as a corporation or an LLC or?
Am I her employer? I'm a person. She works for me.
Yeah, I think. Well, I think the Attorney General's suggestion is a good one and a workable one, which is that the words a person with employees in his service means a person who has the right to control the employment relationship. And in that case, Justice Cordy, yes, you would be such a person.
So I might be personally liable for the wages that my company has not paid her.
If I would modify it a little bit to say if the person's right to control the employment relationship includes the decision to pay or not to pay employees, or when to pay employees. In this case, of course, we're here on a motion to dismiss. This case hasn't even gotten out of the starting gate yet. We expect to be able to prove, if we're given an opportunity to pursue this case, that Mr. Schulman and Mr. Graziano, this is a small company, they both were very much involved in the day-to-day operation of this company, including the payment of employees like Mr. Cook. And in that situation, to insulate those people from any personal liability takes all the teeth out of this statute.
Well, it takes the teeth out of the statute when the company is going under. I mean, otherwise, there are lots of companies that get sued by employees who don't feel they've gotten their proper wages, and life goes on.
That's right. But there are also situations like this one, Your Honor, and many situations like this one, in which it's critical that the employee be able to pursue a claim against someone, and the legislature has made it very clear in the payment of wages statute. This court has looked at this statute quite a bit in recent years, again and again. The statute, I don't think I'm giving anything away, is not a model of clarity or consistency. If it were, the statute would have not come before this court.
20% of our caseload every year be Wage Act cases.
Exactly. So, but I think in this particular case, the question before the court is pretty straightforward, and it's got to be answered in the affirmative. That is someone like Mr. Shulman or like Mr. Graziano who has the right to control the employment relationship, including, of course, the payment of employees, is that person going to be liable as a person with employees in his service? Again, the legislature has made it very clear.
Let me make sure I understand. Does your argument then also include corporations? Because using Justice Cordy's example, he may not be the president and treasurer or an officer having the management of the corporation, and therefore he may not be deemed an employer of the if it were a corporation. But are you saying that your definition is broad enough that it means that there may be other employees of a corporation who may now also be liable?
Beyond the president, treasurer, and person with management of the corporation?
Right.
I think it's conceivable. Obviously, that's not before this court. I think a person who someone was seeking to hold liable would have a good argument that, well, at least with respect to the corporation, the legislature has specifically stated who in a corporation is going to be liable. And I think would be a
liable regardless of whether they participated in any of the tortious conduct, right?
Right, because the language is a person with management of the corporation. It was the issue before this court in the Weidman case, and the court looked at whether the defendant in that case, I forget his name, Higginbotham, was or was not such a person, and they decided that they affirmed the ruling below that on the facts, although the person was a manager of some sort within the company, wasn't the type of manager that was intended by that language in the statute. So I think the corporation presents a different situation. I think again the first sentence of the statute is a catch-all, and it's intended to be a catch-all. The legislature again makes it very clear in this statute, not just in this section, many other sections, that if you don't pay your people timely, if you don't pay them as they should be paid, you cannot shield yourself from liability, whether it's behind a corporate form or some other form, that you will be, a person will be held personally accountable.
Just trying to understand the extent of this rule, though, because there are lots of people for whom other people work in the supervisory sense, but really don't make decisions about whether there's enough money in the account to pay. Is it the people that make the decisions whether to cut the checks? Are those the people that?
Yes, I don't think we're talking about a clerk who was instructed, to write certain checks and not write certain checks. Obviously, the liability shouldn't rest with him or her, but it should rest with the people, as the Attorney General suggests, the persons with the right to control the terms and conditions of employment. That wouldn't be a bookkeeper, but it would be someone like Mr. Shulman or Mr. Graziano, who is making those decisions and is deciding whether or not they're going to comply with the Wage Act and pay their employees timely, or not going to comply. And in that situation, those people should be held liable, and the legislature has said so.
But going back to Justice Gantz's questions, that would include, or might well include, people in a corporate context other than the people listed in the statute.
I think it could. I mean, that case will probably be before the court next year.
But I mean, the
question.
difference, if I'm understanding, well, no, maybe I'm not understanding correctly, but I take it that with respect to the corporation, and lists people who will be deemed the employers in that paragraph 6. President, treasurer, any officers or agents having the management. So they are deemed as a matter of law the employers for purposes of this statute. I take it if you're an LLC and therefore not covered by that language, you really do have to show, as you are saying in the Attorney General, that it's not just by virtue of your title, it's really by virtue of your function.
No, and I think, frankly, when we were before the trial court, that's how the issue was posed. Is someone liable under the statute just by virtue of the fact that they're a manager? I think the Attorney General's formulation is a more workable one because, for example, an LLC doesn't even have to have a manager.
Right.
It can just have members, or it
Well, it's
can.
a functional question.
Yes, it is, and it's something that has to be decided on a case-by-case basis.
Is the definition of corporate officer provision or in the statute, is that an expanding provision or is it a provision and limitation of liability?
You were talking about, Judge, the sentence that reads who the people in the
Yeah,
corporation.
the president and treasurer of a corporation and any officers or agents having the management of such corporation. I mean, it's not, you know, there's a way to read that limits the people in the corporation who could be held liable. It's not everybody in a supervisory capacity.
It could be read that way. Again, that issue has not come before the court. In the Weidman case, the analysis was limited to that sentence. The court didn't consider in Weidman whether the defendant could be held liable as a person with employees in his service. So I think that's the way the court has read that particular section of the law. But I would submit that doesn't really affect how the court should rule in this case with respect to LLCs, which are not, as we know, expressly treated in the statute. That's why that first phrase is so important, because it captures them.
I'm sorry, go ahead, finish.
Yeah, I'm all set.
No, what does your complaint say? What does it allege with respect to Mr. Graziano and Mr. Schulman?
All the complaint alleges, I just looked at it because I was expecting this question, is that, of course, the LLC is liable as an employer, and also that Schulman and Graziano are liable as managers, are liable as employers. I think, though, if I were permitted to amend the complaint, as I would be if this case were remanded, I would modify that by saying that they are also persons with employees in their service. Again, we're here on a motion to dismiss, and a judge ruling on a motion to dismiss, as Judge Josephson did, has to read the complaint in a very generous way. And a complaint should not be dismissed if it can support relief on any theory of law, and it should not be dismissed unless it appears certain that the complaining party is not entitled to relief under any set of facts which could be proved. Your Honors, in this case, we're prepared, if we're permitted by this court, to go forward with this case and conduct discovery and marshal facts which will prove that these gentlemen are both employees, both people with employees in their service, because they both had the right to control the employment relationship. They both made decisions concerning the payment of wages or not, and therefore they should be held liable under the plain words of Section 148.
Now, isn't there a concern with regard to the ambiguity of your definition that if somebody wants to enter into a startup, which is an LLC, that person now has to be concerned that if the startup blows up, as most of them do, that this person now, with that relatively ambiguous definition, may now be faced with having a Wage Act claim brought against them individually? I mean, doesn't it make it a little bit more difficult to walk into a startup where if you're going to have this risk?
Well, you have to balance that against the rights of employees like Mr. Cook, who did go to work for a startup and signed a contract saying he was going to be paid, And when he finally resigned because he wasn't getting paid, he was owed $60,000. And I think again, the legislature has made clear that, the rights of those employees getting paid is paramount. This is a remedial statute, and it's designed to help people get paid and get paid timely, even if that means imposing liability on somebody who just, they were doing the best they could. They started up the company. They weren't able to generate revenue. But again, the interest of the employee is paramount, and that's what the legislature has said, and that's what this court has recognized in looking again and again at this wage statute. It's a remedial statute. It has to be read broadly to achieve its purpose. So I would just conclude by saying that we're asking that the court reverse Judge Josephson's ruling dismissing Mr. Cook's claims and permit this matter to go forward so Mr. Cook can pursue those claims as he is permitted to do under the Wage Act.
Thank you, counsel.
Thank you.
Good morning. My name is Marwan Zubi. I represent the defendant, Michael Schulman.
And the other defendant?
Is unrepresented, did not file a brief in the appeal. For all intents and purposes, for the purposes of this appeal, their position is the same.
Right.
I would submit that factually they had very different roles in the limited liability company, but for the purposes of the appeal, their positions are the same. I think we've been talking about so far, based on the Justice's questions, what the law should be, but we need to focus on what the language of the statute is and what the legislature intended. This court has already decided, in another case with respect to another statute, what the phrase "persons with employees in his service" means. In the case of Commonwealth versus Sintolo, 415 Mass, I believe it's 358. This court said what that phrase means. In fact, to be more accurate, it ruled what that phrase doesn't mean. It doesn't mean the president of a corporation. That phrase means the employer. What the plaintiff wants you to do in this case is something that's never been done before. In the 80-so years that this statute's been in existence, no one's ever interpreted that phrase, employee or persons with employees in his service, to be anything other than the actual employer. There are two categories of persons or entities who can be liable under Section 148. The employer, that person or entity is easily identified. It's the person or entity with whom the employee has an agreement. It's the person or entity who pays the employee. That's the employer. The statute has added to it another class of individuals who may be liable for a violation of Section 148. They went back and added to the statute the president and treasurer of a corporation or the persons having management of the corporation, and they added public officers who are, I'm not using the words exactly, but who are responsible for the payment of wages. The legislature did that. The only reason the legislature had for doing that is because the legislature recognized that the phrase "persons with employees in his service" meant only the employer, the single entity or person who employs employees. They wanted to add to it other categories, other persons or entities. Why did they add to it? I believe they felt they wanted to strengthen the statute by putting officers on notice and corporate officers on notice and public officers on notice that...
It's just public corporations?
I'm sorry?
This is just public corporations?
No, it would be, you mean publicly traded?
Yeah.
No, it would be private corporations as well.
Oh, so even small corporations?
Absolutely.
And, family-held corporations and...
Certainly, because that's what the statute says. The statute does not say...
But that's because there were no LLCs when the statute was enacted in 1935.
That's true.
So how do we interpret Their intent to focus on all entities, which at the time happened to just be corporations, or to be, they say corporations, they mean corporations, and let them amend.
They say corporations, they mean corporations. It's true, LLCs didn't exist at the time. But this court, as it has said before, can't go back because of a change in circumstance since the statute has been enacted and effectively rewrite the statute. That's for the legislature to do. We can't, the court cannot now, because now LLCs exist, say, okay, we on our own are going to have it apply to this new entity. It's clear what needs to happen here. The legislature, if they wanted to apply to limited liability companies, needs to go back and amend the statute. They need, as they did before with respect to corporations, as they did before with respect to public officers. They haven't done it yet. This court cannot do it. This court should look also to the Limited Liability Company Act, Chapter 156C. Section 22 of the Act, in relevant part, provides the debts, obligations, and liabilities of a limited liability company, whether arising in contract, tort, or otherwise, shall be solely the debts, obligations, and liabilities of the limited liability company. No member or manager of a limited liability company shall be personally liable, directly or indirectly, solely by reason of being a member or acting as a manager of the limited liability company.
I don't think the argument is that solely by reason of being a member should these individuals be liable. It's for the functional role that they play.
But the statute doesn't talk about the functional role. The statute.
That one does, though.
This statute does. That's correct. But Section 148 doesn't.
Well, I understand that, but I'm just saying I don't think that the Limited Liability Act, the language you just read, helps us very much here, given where the plaintiff is coming from.
Now, do you agree that under 27C your client could be criminally prosecuted?
If he were I do. If he were liable, if this court concluded that any member or any manager of a limited liability company can be liable for
No, I'm saying let's assume you prevail here. Let's assume you prevail in your argument.
Yes.
Do you agree that under 27C he can still be prosecuted?
No, he cannot.
Why?
Because you're only one. We have to remember 27C applies to a whole slew of statutes, sections under the Wage Act.
But this one included,
This one included.
right?
But for him to be liable for a criminal violation under 27C, I respectfully submit that he has to have been found to have violated Section 148.
Okay, so if does that go to whether or not our interpretation of the statute should be applied prospectively or not? Like, does the next, if we were to decide against you, would the next generation of cases under this particular statute result in criminal liability to managers of LLCs?
Yes, I believe Section 148 has to be treated as a criminal statute. It's a crime to violate Section 148 because 148 itself says if you violate this, you're violating 27C, and 27C applies to 148. So we have to look at this language strictly, as this court did in Commonwealth versus Centola.
But your argument can't hold up because 27C includes superintendents and foremen or employees who would clearly not be themselves personally liable for it, but they can still be criminally liable if they cause their employer not to pay the employee.
That's true, Your Honor, but those words, superintendent, and there are several other persons, those persons are specifically referred to in those other sections, not 148. In those other sections listed in 27C, it mentions supervisor, it mentions superintendent, it mentions, so the statute, instead of, the legislature tried to do it quickly, tried to do it in a summary fashion.
You say that, but the language is pretty clear. I mean, it seems to me that if somebody that works, somebody in the position of Mr. Shulman, who is an officer, agent, et cetera, of an employer, I'm taking your argument that the employer is only the LLC, and if he willfully or without a willful intent, if the employer willfully or without a willful intent violates 148, it seems to me that he could be criminally liable under 27CA 1 or 2, depending on the facts. if the employer violates
148.
Right.
But that's the key.
The
Has to be
violation
a
of 148.
violation of 148.
Exactly.
By the employer.
Justice Court, I agree with Justice Cordy. is
Employer.
right. The
So
employer.
27C doesn't spread liability to supervisors and others with respect to
That's right.
148.
That would be,
No, but my point is, if the LLC violated 148,
yes.
then it would seem to me that your client, Mr. Schulman, could be criminally prosecuted under 27C.
And do you say that because of the language of 27C, or do you say
Correct.
that because he's
No,
in
it's-
charge of the corporation?
No, I say that because of the language of 27C.
I respectfully disagree. I think what the statute was intended to apply to all these different sections that mention different classes of people, supervisors, superintendents. There are several, as you can see in 27C. There's so many sections that it applies to. It also applies to employee. How could you say that an employee of an employer who has nothing to do with the payment of wages of that employer could be criminally liable under 27C if a coworker is not paid wages? It doesn't make any sense. It has to tie back to the violation of 148.
In other words, the entity who has violated 148 may be pursued
Right.
under 27C.
And if we read the statute.
Or individual, if it's an individual employer.
Exactly, it could be an individual employer. If we read the statute the way that the Cook wants you to, the language that the statute added, president, treasurer, public officers, has no meaning. It would be inoperative. If the first phrase includes everybody, why did the legislature go back and say these people shall also be deemed to
Well,
be the
couldn't it be
employer?
construed as words limiting the liability of certain limiting the liability of certain people within corporations? In other words, it's not every manager of a corporation, it's the president and the treasurer and certain agents having management of the corporation.
I think, respectfully, Your Honor, I think the better way to read it is persons with employees in his service is the employer, and then the legislature went back and wanted to broaden that. Who else are we going to deem the employer? The
Well-
president, the treasurer.
Doesn't the Attorney General suggest another way of looking at that, which has to do with other provisions that otherwise deal with corporate officers and the shield for corporate officers that is much broader, absent express statutory exception? And so in order to be able to reconcile those, you had to be able to have a statutory provision that expressly identified corporate officers' liability.
I understand the Attorney General's argument in that regard. I don't know that it matters, because we have to look at 148.
No, but it responds to your argument that it would mean, that it would be meaningless if you, I think that the Attorney General is trying to give you another point of view on that it doesn't render meaningless. There would be a specific reason why you would have it, notwithstanding the broad language of the statute.
But the legislature also amended the statute to include public officers that have nothing to do with corporations, but work for the Commonwealth or a municipality. And if they're in charge of the payment of wages or involved in it, they can be liable under the statute. The legislature has not.
Would they otherwise also not be liable? Would they otherwise not be?
If
not
that
have
language is not
personal-
included,
Yeah, if that
they
language.
would not be liable.
Right.
Right. But for those two provisions, corporate officers, public officers, the only person who would be liable for a violation of 148 is the actual employer. And if we all agree that the law should be different, it should apply to members and managers. Remember that a lot of LLCs are run by members. An LLC could have 500 members. Are they all liable for a violation of the Wage Act if an employee is not paid wages?
Well, if there are 500 partners in a partnership, aren't they all liable?
That would be true, yes. But that's a distinct entity. And there's nothing in the law that says a partner of a partnership is not liable for the acts of the partnership.
So why should LLCs have favored status? I mean, certain corporate officers are responsible for paying the wages. Partners are liable for paying their wages? Why?
Well, corporate officer, again, in this regard, LLCs are more like corporations. They are, it's a liability shield. We all recognize that. That's the purpose of them. The members or managers are not personally liable because their members are managers. Corporations are like that. Partnerships are not. Corporate officers are liable for a violation of the Wage Act because the statute says they are. The statute does not say that it applies to managers or members of a limited liability company.
But the Attorney General's position on this is that limited liability members do not have the same kind of shield as that of operators.
I disagree. The language of the two statutes, the corporate officer shield and the LLC member manager shield, is a little bit different, but I respectfully submit that they both have a liability shield. And to say that, okay, we're going to look at the act of the statute doesn't say, and maybe it should say, but it doesn't say people who are involved in the payment of wages to employees who participate in the failure to pay an employee wages are liable for the act, are liable under this section. Maybe it should say that, but it doesn't.
You're not saying that members of limited liability corporations have no personal responsibility for tortious activities that they conduct?
I think that's a different question. I don't know that it's been decided. Perhaps they could be. But here we're dealing with a statute that can be criminally applied. We have to read the language of it and decide what the legislature intended.
Well, your time is up. Thank you, counsel.
Thank you.